Hello, good afternoon, everyone. Welcome to the Learning Exchange. Sorry. Yeah, we have an intruder. Apologies for the sick kid. So welcome to our, I may have to pass this on to Sarah if he doesn't keep. So welcome to our Learning Exchange. The title of today's Learning Exchange is Using the Civil Protection Order as a Tool for Economic Justice. At CSAJ, our mission is one that promotes advocacy approaches, that removes systemic barriers, enhance organizational responses, and improves professional practices to meet the... Sorry, this is not going as planned. And improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. We envision a world where everyone has equal access to physical safety, economic security, and human dignity. I hope everyone was able to hear some of that. Without further ado, I'll hand it over to Erica. Please feel free to introduce yourself in the chat. Would like to know who we're speaking to and start the conversation. Thank you.
Hello, everybody. Welcome. And thanks, Nkiru, for the introduction. Can everyone hear me all right? Great. So today we are going to be talking about using the Civil Protection Order as a tool for economic justice. My name is Erica Sussman. I am the founder and the executive director of the Center for Survivor Agency and Justice. I have the pleasure of working with Nkiru and Sarah and Jazz, who are with us today, as well as other CSAJ staff, and just really thrilled to be here with you all to talk about a topic that I think is an important one because it provides so many advocates with a tool for expanding the way that we do this work. So thank you all for being here. So I'm going to ask folks to mute yourselves. We're actually going to be talking a lot. There'll be lots of opportunities for interaction, and so definitely not wanting to mute that. But yeah, if there's some background noise, please go ahead and press mute. Nkiru mentioned our mission and vision. CSAJ is a national organization that advances economic equity for survivors, and we do that through multiple levels of impact by supporting the work of individual advocates, by enhancing organizational responses, and also by working to fuel systems change work. Today's presentation and conversation is really grounded in the lived experience of survivors that I've worked with in the past, and hopefully will also be grounded in the lived experience of survivors with whom you all work, because I'll be reaching out to you all and inviting your participation in this work. This conversation, just to give you a couple of examples, comes from some of my experience representing survivors in the District of Columbia. For example, Barbara was one survivor with whom I worked who came to this country on the promise that her father was going to take care of her. She was a teenager at the time and was hoping to go to school here. Instead, what she found was that really she was terribly treated by her father, and though she got a protection order against him, without his financial support, she really found herself living impoverished, working at low-income jobs, working at McDonald's and other sort of fast food places, and struggling weekly to make ends meet. And I remember her saying to me, if I had known what this country would be like, I never would have come here. So there was a clear economic piece that put her safety at risk. I also think about another client that I worked with, Monique, who had been abused by her boyfriend on just one occasion, but the medical injuries were so extensive that it required multiple surgeries. And for Monique, she was determined to collect all of the money that she incurred as a result of those medical costs. That is what justice meant to her. And really, that example expanded my thinking around how do we use protection orders or whatever the civil legal tools are at our disposal to make sure that people's economic needs are met and that their own personal definitions of justice are also. So we're going to spend our time together today. It's my hope, talking about drawing from not only experiences like these, but really hoping to hear from you all in terms of how protection orders have worked in your own practice and thinking creatively together about how we can elevate their usefulness. Here's an overview of the webinar or our conversation today. First, we're going to talk about the why of this, why economic advocacy is so critical. And I think that is common sense to all of us, but sometimes is helpful to think about explicitly because that enables us to weave it into our civil legal advocacy efforts to folks who may not really understand that at first.
No, I think you get it.
We're also then going to turn to talking about the broader landscape of economic relief and civil protection order laws, taking a look at what different states provide for, either explicitly or less explicitly, and we'll chat about what that looks like and how we might be able to borrow from different states. Then we'll turn toward practical advocacy strategies. So again, really hoping that you all will roll up your sleeves and dig into this alongside me, because this is really much more of a topic of doing than listening. So in that vein, I also encourage folks, if you're comfortable and feeling like you want to, please take yourselves put yourself on camera if that works for you. When there are opportunities for questions, you're welcome to speak those questions. If you're not comfortable with that, feel free to chat them. But we have a relatively small group today, so definitely welcome this as a working workshop together. And then at the end, we're going to leave some question and answer time. So that's the overview for today. Before we dive into this, I know that we're all coming at this work from different places, but all from the place of advocacy. So when you think about civil protection orders, it begs this question, what is the role of the advocate? So the role of advocate in civil protection order proceedings varies from state to state, jurisdiction to jurisdiction, courthouse to courthouse. Because of all of that diversity in terms of what advocates do in this discrete legal context, I'm going to talk pretty expansively with the idea that we'll talk about like the universe of possibilities, and you will be able to think about in your own particular organizational context and your own jurisdiction, what does this mean for you? What pieces of this might you be able to do? What do you need to do alongside or in partnership with others? So not suggesting that folks engage in the practice of law, but I am suggesting that advocates dig in really powerful and impactful ways, as we always do, to figure out how best to leverage skills and knowledge of these often challenging and inequitable systems that survivors face. So I've got a question for you all and invite you to respond. The first is a survey. So I'm going to ask, thank you. So what are the types of protection order advocacy that you are currently engaged in? What is your particular role? Some of the options are drafting petitions, gathering evidence, so helping folks to find documents that will be helpful in their protection order, seeking court accompaniment, and support, or more than one of the above? Great. So I see gathering documents and evidence and a lot of court accompaniment. I am not seeing helping with drafting petitions, which is interesting to me. Okay, great. Thank you for that. I'm going to end that poll and just ask that you, oh, I'm going to show it to you. Sorry about that. Try not to hog the results to myself. And then my question for you in chat, or if you want to speak it, is what are the other types of things? If there are things beyond gathering evidence or documents or court accompaniment, are there other types of roles that you play in helping survivors to get protection orders? If you want to chat about that, go for it. Great. Oh, I do see somebody saying that they do draft petitions. Great. And connecting with childcare. Yeah, I appreciate that. So we know that just seeking civil legal protection is a drain on resources, right? People need to make very complicated choices about, is it worth me going to the courthouse to do this? What's the likelihood that I'm going to be successful? And what are the impacts on my employment, on my childcare, et cetera, et cetera. So yeah, I really appreciate all of the sort of wraparound economic support, so to speak, that advocates need to provide in order to make this feasible and make this a feasible choice for survivors. So thank you for that. Okay. So again, today's session is really about taking a look at civil protection order advocacy and asking this question. What does civil protection order advocacy look like when we place economics at the center of our thinking? How does that change both our thoughts about how the harms that survivors might be addressing, as well as the strategies that we as advocates might employ? So this is using a different lens type of question. Again, so we know that the relationship between domestic violence and poverty is clear. There's a lot of research that illustrates it, as well as just, and not only research in the formal sense, but just lived experience and all of you bringing from your own work on a day-to-day basis. We know that people who are accessing public benefits report very high rates of domestic violence. And we also know that there have been lots of studies dating back to this one conducted by Sullivan and colleagues around a scale of economic abuse, which really has driven a great deal of CSAJ's work, which showed that survivors who were being interviewed, 99% of the folks interviewed indicated that they had experienced some form of economic abuse during the course of their relationship. And in fact, this percentage was even higher than those who reported physical abuse. And we know that economic abuse takes the form of economic control as well as economic exploitation. So moving to the context of protection orders, with that kind of link between economics and physical safety, I want us to take a step back and just think about what are civil protection orders, because I think that lots of times we as advocates, we know that we're doing the work. We know that this is a tool that's been available for decades now, but thinking about what is its purpose and how is it different from other forms of civil and criminal protection. So civil protection orders provide domestic violence survivors with a tool for accessing safety. And in this context, I would say economic safety as well as physical safety. One important distinction that I think is useful for us to center is that unlike criminal justice remedies, where the state wields control over initiation and pursuit of the case, civil protection orders are intended to provide survivors with some level of control over whether and how to initiate the case, what type of specific relief they're going to pursue, as well as whether they're going to enforce the civil protection order if that relief doesn't come to them more freely. So there's a distinction in terms between civil and criminal systems in terms of survivor agency, for sure. We know that civil protection orders are injunctive in nature. In other words, there are provisions that order abusive partners or harm doers to refrain from certain actions or to engage in prescribed acts for a period of time. And I say for a period of time because protection orders are usually temporary in nature. There are some states that are for a very long time, but most states, protection orders, of course, are for 1 year, maybe 2 years. They're also greatly underutilized in terms of the economic piece of things. Even though technically speaking, most civil protection orders explicitly, if not implicitly, provide for economic relief. Because we know that the statutory intent of civil protection order statutes is, simply put, safety. So if every single state has safety or violence prevention at the core of its legislative intent, and we know from what we were just talking about that economics is critically linked to people's long-term safety, then the argument that we as advocates have to help survivors to bring to the courtroom setting is that in order to achieve the purpose of the civil protection order, judges need to incorporate economic remedies or material resources into their civil protection order awards. That you can't achieve the purpose of the civil protection order without attending to those economic needs. So that's a challenge and a creative one, but that's what advocates do. Lots of creativity and lots of making connections for folks and educating folks who may not have a really clear understanding. I want to, before we dive into the how of it, talk a little bit about this hesitation, because there is a lot of hesitation amongst advocates, amongst judges, amongst survivors in pursuing economic relief and civil protection orders. So if you can, again, turn back to your chat. And yeah, if you want to throw out some answers to this question, what are some of the reasons for hesitation to do economic civil protection order work? Why that?
Personally, every time when I have there's been a survivor, somebody that's already been through domestic violence. They've been through a huge amount of the process. And then when we go to look at their credit and stuff and start to fix it, it brings up this hesitation of having to enter that whole process again because of the process of achieving it, I guess is what I'm trying to say, is like the whole filing for the identity theft and stuff. And it's very hesitant because they just got done with having to go through a majority of it, because rarely are they connected. Rarely do you do them at the exact same time as the actual domestic violence case itself. Yeah. And if there was a way that was easier to just reference that so that there's not that re-traumatizing and because the criminal case of it should be the evidence enough. It's just the paperwork that goes along with it doesn't allocate for that allowance. Like there needs to be a difference in the way that that paperwork is done, I guess, is what I'm saying, is there's no allocation for it in no way for that known evidence that's there can allocate and achieve those goals. Does that make sense?
That makes sense. Yes. I think I actually heard you say two things. One of the things is this person has already been through an arduous and traumatizing sometimes and exhausting legal process. Neither I nor they want to go back to the courtroom and go through more work in order to get at some of these economic pieces, which aren't known. I think what I'm hearing you say is that some of them are not known until later. And so really having to reopen that box is a challenge. Great. Thanks for offering that. Are there any other pieces that folks want to lift up in terms of reasons for hesitation? Because they are real. I don't want to jump over them. And they are things for us to work through.
Can I speak to something in this space?
Yeah.
All right. What I would like to add on, and this is more specific to immigrant survivors, is when they have their immigration papers being done by their spouse or partner, one of the hesitations that come up for immigrants is not necessarily seeking economic compensation because they are afraid, number one, if they can't own or have a bank account, where does the money go? And then number two that comes across is if their paperwork is being done by someone that has status in the country, it really puts them into contact with systems that they cannot necessarily be in contact with at the moment, if that makes any sense.
That makes a great deal of sense. And thank you for offering that. So one of the pieces that I hear you talking about is just even engaging in the civil justice system itself for many immigrant survivors is scary, and for very good reason, given the risks that it poses to their immigration status and the physical safety risks stemming from that, as well as a dependence, not only in terms of economics, but in terms of immigration status for immigrant and undocumented or otherwise folks who have immigration needs that are reliant on their abusive partner or other folks for that matter. But yeah, that's really important to think through and needs to be integrated into the client counseling portion of this because it really is a safety planning exercise. Yeah, I appreciate you sharing that.
There's a comment from Janet that says, I don't know if Sarah could read it. It's
Sure, let me see.
Yeah, again, lots of nods and plus ones to the comment about barriers, challenges to immigrant survivors. And then on the flip side is the survivors being how quickly the process can go, and survivors being having hearings set up really quickly, so there's not a lot of time to prep and to dig into financial needs. And I can imagine the barriers and hesitations and challenges that come along with getting a bit bamboozled by the system. And so they don't know how much their abusive partner makes or about certain bank accounts, and sounds like when they're already in the midst of a case or navigating the system.
Thank you all for that. And we're going to make sure to hold those considerations and others as they come up in the coming conversation. So here are some other pieces. There's also a huge judicial reluctance oftentimes, especially when there's an accompanying divorce case or other family law case. Oh, it'll be dealt with, and economic things can be dealt with somewhere else. There's a very quick, fast-paced protection order culture, so to speak, that really poses due process problems. There is you all talked about safety assessment, whether it takes the form of retaliatory violence or abusive litigation tactics. There's a lot of frustration around, can this even be enforced? And I'm sure that we could add to this list as well.
I have another question is like, when we've seen in like on the news and stuff where somebody at say like an assisted living place or whatever has stolen identities of clients that were there or their information, that person goes to jail and gets out, hits hard times, and they fall back into using that information they had, where as criminals they do that. How do you go about helping a survivor who had that previous known connection in that relationship there of that known case? How do you use that as the grounds to help that survivor down the road when their information has been used now again, and that they have to seek that economic safety and that protection of an economic order, but it's that previous thing that was happened before as the grounds. I've had issues with that before.
Yeah, I appreciate that. And it opens up really rich conversation for us to think about what can be done in the civil protection order context around identity theft, which is, you're talking about identity theft. So what can be done in the civil protection order context? What can be done needs to be done in terms of coordination with consumer law cases that are specifically defending against debt. And it also sounds like, the possibility of thinking in the context of criminal cases. How do we lean on a history that you're talking about of identity theft to potentially benefit survivors or add context to the current coerced debt that a particular domestic violence survivor might be experiencing? So all is to say, we need to think about this in the context of a much broader plate of civil economic justice work, as well as other, even outside of economic justice, whether it's the criminal justice system or other civil or non-legal remedies. So I appreciate you highlighting all of those pieces. We're going to dive right in right now to the how of this, because this is really about broadening the lens, making sure that the economic impacts of domestic violence, whether they are economic abuse directly or domestic violence more generally and its economic impacts, that they're not just extra legal casualties that survivors experience, things that don't have a remedy, but rather that they're seen as and addressed as core legal injustices that are deserving of legal protection. Because, as we like to say, there is no safety for survivors without economic security. We all actually have just started to do some of the answering of this question so far, so thank you for that. What are some of the types of conduct that could justify court-ordered monetary relief, or relief that's tailored to enhance somebody's economic well-being? I'm going to ask you to use chat for this, because something tells me that you all can come up with dozens of examples of this. So types of behavior that you'd be able to say, judge, this feels like something, an economic harm or an economic need that's connected to safety. So feel free to share some ideas there. Okay. So some of the needs would fall into the bucket of economic abuse, right? Direct, either an abusive partner using control or exploitation. So examples of that might be educational or employment sabotage, credit destruction, identity theft, stolen money or forged checks, debt, using joint accounts to run up large bills, or coercing a partner into taking on debt in her name. Loss of housing, right? Abuse might lead to eviction or refusal to make mortgage payments, rental payments may lead to foreclosure, and what are the rippling impacts of that? Other examples that you might point to from your own advocacy where there's been economic abuse that you could think about, a protection order could be useful in that context. I'm going to move on. In addition to direct economic abuse, we also can think of civil protection orders as addressing the economic impacts of physical or other forms of abuse. So physical abuse that results in economic damages. That might mean somebody suffered injuries requiring medical attention, doctor's visits, counseling or therapy for oneself and one's children, destruction of property, loss of property. All of those types of economic damages are things that can be addressed through a civil protection order. And really all domestic violence, because again, going back to this link between safety and economic security, the argument that we're making is that civil protection orders are at their core about violence prevention in the future. And so we want to be able to show how being restored for past economic harm, as well as thinking for the year ahead, what are the economic needs that this person needs to have met in order to stay safe during the course of the civil protection order. So really thinking very expansively about economic relief in this context. And that might take the shape in a civil protection order of either money, a court ordering X amount of dollars, or it could be access to resources, whether it's housing access, access to equipment that is deeply connected to their economic well-being, access to transportation, childcare, all of that. So I'm going to jump into talking broadly about what the law offers when we take a step back. Before I do that, I do see that there's a lot of chat going on. Are there any things that we want to lift up before we dive into the broad landscape of civil protection order? And I'm going to ask Nkiru and Sarah if you can highlight anything worth us diving into. I see, yeah, I'm looking at it right now and I'm seeing lots of great ideas in terms of the types of economic harm. Sounds like you all may be doing this work or just in a place that this resonates. So I appreciate you sharing your reflections. Okay. Let's talk about the landscape of civil protection orders as it relates to economic security. There are several common categories of relief that are specifically provided for by many state civil protection order statutes. So really discrete forms of economic relief. And this varies from state to state, but they fall into some general categories. And then there's also pretty much every state has a catch-all provision that offers a mechanism for accessing economic relief, even when it's not specifically carved out. And that's where a lot of the creativity needs to take place. So I'm going to march through this with you all, knowing full well that you're not necessarily going to have every specific provision available to you, but other states' provisions can give you some ideas about what you might ask for, and also helps to make creative arguments under your state's catch-all provision to draw on some examples from other states and make it clear that like I said before, that the general legislative purpose will be fulfilled by doing what other states have done. Specific provisions. One is restitution. Restitution orders, the court is allowed to order damages for direct economic damages resulting from abuse, property damages, clothing, medical expenses, therapy costs. And you can see an example here from Delaware's code that gives very clear opportunity for folks to get restitution. I don't know if there's a hand raising function, but I'll just ask the question for you all to consider: how many have worked with survivors to get some kind of economic restitution in the course of protection order work? And feel free to either chat it. There's also housing provisions, and these vary a lot from state to state. So most state protection orders have some provision that specifically addresses housing. In some instances, like you can see here, In the Alaska statute, it's regardless of who owns it. So even if a survivor does not own the property, the court is permitted to remove and exclude the respondent from the residence regardless. Some may depend on petitioner's ownership rights, if it's jointly owned or if the petitioner owns it herself. There's also housing provisions that order a respondent to pay for mortgage payments or rent payments so that she's able to continue living in the residence. And then some that talk about it in terms of alternative housing arrangements. You can see an example here from Missouri, paying the petitioner's rent at a residence other than the one previously shared, because there may be safety issues connected with that as well. So here are, I share this with you as a range of different opportunities for economic relief related to housing. Then there's some that are related to property. And usually, because this is a short-term civil protection order injunctive relief, there are property concerns tied up in that. And so most civil protection orders are connected to temporary possession or use of the property, right? Not ownership, because there are all sorts of objections that would come up in that context. But for example, here, Georgia is providing for possession of personal property. If somebody, I can think of one person that I worked with who had a printer that they needed it to hold on to in order to continue to do their work, or a computer that others may have had. And so really granting somebody the ability to continue to possess that during the course of the protection order is critical to their economic well-being. There's also protection of property, because we know so oftentimes in retaliatory violence, a respondent might try to destroy somebody's property or hold on to it, hold on to funds or hide funds. So this particular type of provision explicitly forbids the respondent from doing that. And of course, protection orders can get really specific about what. Other specific provisions are support payments, whether in the form of child support or spousal support or both. How many of your states have statutes that specifically allow for temporary child support or spousal support? Many states allow survivors to access temporary child support or spousal support. So that is during the course of the civil protection order. It's irrespective of what family court hearing may later determine. Again, it's just really geared toward this safety piece of the protection order proceeding. And it's temporary in nature.
There's some stuff in the chat. A few people are saying, Erica, that judges will not sign off on child support or alimony on the protection order. They'll deny it and state that it's a custody or divorce issue or requires some other civil suit. So curious if there are strategies around that.
Yeah. Yeah, I appreciate that. I would be curious to hear in those contexts whether the protection orders, whether the protection order statute explicitly is offering support payments and the judges are saying no. So there's a lot of context to navigate through there. I know through my own practice that I often found that if there was a companion family law case or a companion long-term child support case happening at the same time, that yes, judges were going to say, I don't need to determine this in my courtroom right now because there's a family law case that's happening several months from now or a year from now, and it'll be determined then. My suggestion in that context is this person can't wait for a year from now to get child support. It literally means, the difference between them having economic security to stay safe and less vulnerable to their partner or not. So really in that instance, and again, there's judicial sort of culture operating there that is very real, trying to illustrate, and I think survivors are best situated to do this through their own sharing of their own context of their lives, what would be the real impact of not having child support payments between now and a year from now when a permanent order is put in place. So yeah, thanks for highlighting that. Other provisions, just quickly, can be in the space of liens, encumbrances, and debts that are due. So we talked earlier today a little bit about the ways that identity theft shows up, and just coerced debt more generally. Civil protection orders often provide specific provisions that can order a respondent to pay utilities during the course of the protection order, health insurance payments that are ongoing, as well as debts that will come due during the course of the protection order. So again, taking a careful look at, does your state have a provision like this? How does it connect to the specific facts of this petitioner survivor? And how can we engage in some storytelling so that the judge really understands the impact of not granting and the impact of granting these types of relief? Here are some other examples: lost wages, attorney's fees, relocation and moving expenses, as well as stay away provisions, right? Because we know even though stay away provisions sound like they're physical injunctive relief, they often have economic implications, especially when somebody is engaging in harassing behavior at one's place of work or somebody trying to go to school and facing some dangerous consequences for doing that. So just thinking about how all of these provisions might play a role in somebody's ability to access greater economic well-being. This is a very unusual example, which is not only does this statute provide lots of detail about economic compensatory relief, including reimbursement for a whole range of different economic impacts, it also goes a step further and says that where appropriate, punitive damages can be awarded in addition to compensatory damages. So that's an unusual statute. I don't know from New Jersey folks, not sure if any are on the call today, but is that provision something that folks have ever seen? I'd be really curious. Seen used, I'd be really curious to hear about that.
I'm in New Jersey, and I've done quite a few restraining order hearings. I always go with client to hearings, and I'm shocked to read that because New Jersey, especially recently, in the past couple of years, will not even allow clients to get child support. They won't do it. The lawyers at Central Jersey Legal Services, which is the agency by us that provides services to low-income families, they won't even ask a judge for it. They won't even do it. It feels like monetary protections are something that they don't want anything to do with. And also, I don't know if this is true, it's similar in other states, but in New Jersey, generally speaking, so final orders in New Jersey are permanent. There is no end date.
That's right. Yeah.
And they, generally speaking, the final restraining order hearing is scheduled within 3 days of the granting of the temporary. Even if you want to ask for monetary justice, you have to bring proof. You can't just go to court and say it. And it's just literally not enough time. A lot of times clients they know nothing about the financial situation. I have lots of clients who don't even know how much the abuser makes. They have no idea.
Yeah, thanks for raising that. So we're going to talk about all of that right now, the how-to piece of this.
That's very exciting.
And I And yeah, hearing some of those things is really helpful because it really shines a light on the gap that exists between what the law says and what survivors are getting in practice. So as advocates, being able to help bridge that gap is just such a huge and powerful way to support folks. So let's talk about that.
And really quick before you move on, there is someone asking in the chat that they're not aware of or sure about if there are specific economic relief provisions for PPOs in their state, suggestions on how to go about getting it or finding that.
Yeah.
Can certainly relate to as a non-lawyer and an advocate, how do you start to get your bearings around? And this may not be what that person is asking, but that's my mind. How would I go about figuring out the list of provisions and so I could partner and figure out things in my state?
Yeah, appreciate that. People need to familiarize themselves with their civil protection order statute, including the economic pieces and really the full statute. To do that, I can think of a few ways to do it. We can provide this link, if not during today's program, afterward. Law.org, I believe, has a full listing of every state's civil protection order statute. And so you can look up what your state's civil protection order statute is. I also think it speaks to the need for partnership because folks who work at civil legal services as lawyers certainly have access to a lot of legal research and should be able to connect local programs with their civil protection order law and partner with them as well in places where sometimes lawyers might be helpful, sometimes advocates. So really developing a partnership with your local civil legal aid or legal services office is another way, because it also allows for collaboration and some cross-training there. But yeah, really getting familiar with one's civil protection order statute is a good first step, and training on that, I'd want to know about more locally within your state, what kind of training is available for advocates. So that could also be done through your state coalition, and yeah, just trying to get rooted in the local context of civil legal protection. So I talked about catch-all provisions, and I just share that because it's a really exciting way to get creative about this. In the District of Columbia, our statute says that courts can grant relief that is quote unquote appropriate to the effective resolution of the matter. Okay, so this is equitable relief. It is not specific to economic relief. However, case law has mapped out that it does indeed include monetary relief. So courts have determined that in order to resolve civil protection order cases, economic relief is something that can absolutely be granted in all different shapes and forms, because as this one court recognized, financial dependency was a major factor in the perpetuation of a long history of violence in this family. Again, as you examine your state civil protection order statute, take a peek at what type of broad provision exists within your statute. It's not going to have the same exact language, but I suspect there will be something there for your interpretation and creativity. Here are some other examples from North Carolina and Ohio and Pennsylvania, broad relief that folks can leverage. Okay. Can folks just briefly, because we've talked a lot about hurdles, which we need to problem solve. I guess I'm just wondering, as I share this, does anybody want to chat about, in your protection order advocacy, what are some examples of really creative economic remedies that you have seen courts award? Does anybody have examples of that you want to share for inspiration? I'll leave that as an open question because we're going to show some examples of that as we go. So this process of economic relief advocacy in the protection order context is one, like I said earlier, of really shifting our lens. So we need to wear our economic justice glasses from start to finish within the advocacy process. So from client intake and interview and counseling to the drafting of petitions, to presenting evidence and testimony in court, to the arguments that are made in court, to modification hearings. I want to talk about that because a lot of people have talked about the we don't know yet, and modification hearings are the thing that provides an opportunity to modify the protection order. One, if you didn't know about economic things or weren't able to think about it early on, people have an opportunity to go back to court and modify the civil protection order to incorporate that. As well as enforcement, right? Because we could get the most beautiful civil protection order in the entire world that has all sorts of economic relief. And if the respondent does none of it, then that's not helpful. And so being able to think about enforcement, whether through courts or through other ways of navigating institutions and leveraging the civil protection order to access that relief. So really, let's all put on those economic justice glasses and dive into the process right here. So here is a story to get concrete on that. Sally met her husband in Sierra Leone, which was her home. He was a US citizen visiting for the summer. Several months after she moved to the US, her husband began abusing her in all sorts of ways, including economically. On one occasion, he, jealous of a friendship that she had developed with a neighbor, he called her a whore and punched her repeatedly in the face, with one punch landing on her eye. The following morning, she went to the hospital and needed surgery, and she's been told that she'll need follow-up treatment. About 6 months ago, her husband had pushed her into their bedroom and locked her in, and he destroyed all of her clothes that were hanging in the closet, and then held a knife to her and demanded that she have sex with him. Over the course of their marriage, her husband would routinely steal paychecks, deposit them in a checking account, which was in his name. And then 2 weeks ago, Sally discovered a bill from a credit card company on the kitchen counter. She had never applied for a credit card. When she contacted the card company, she learned that the card was in her name, that her husband was an authorized user, and more than $2,000 had been charged on the account. Her employment authorization had expired 2 months ago. She's been relying on her husband to renew it, but he hasn't. And she wants to move from her house now because her husband is friends with the building manager and doesn't want to live in the same space where she had experienced her husband's abuse. Okay, so that is the story that we're going to work with. Lots of different pieces to it, as is usually the case with people's lives, in terms of the ways that abuse shows up and also the complexity in some of the decisions connected to both physical safety and economic well-being. So we're going to work with this story. And first, I want us to start from what is often for us the beginning, interviewing and counseling. So here, really, it's about identifying both the prior harms that this person has experienced as well as the future costs, right? So prior harms, identifying what's the economic impact of individual instances of violence here? And what are some of the future costs of safety? So I want you all to think a little bit about what that would look like in Sally's context. I'm just pausing because Okay, so if folks want to chat a little bit about that, feel free to offer up some ideas. Prior harms that have been that are illustrated by this example. What are some of them? And again, doesn't mean that you're necessarily pursuing all of these, but in the brainstorming process, what are the possibilities? Prior economic harms, as well as some of the future costs that Sally might have in trying to stay safe moving forward. So feel free to chat some of them here. Get an example back up, please. You know what? I'm gonna, yeah. Here it is. Maybe we can copy this story and put it in the chat, because we are going to be marching forward in this. And I understand folks not wanting to be able to see it as we do that work.
Sure. Someone is saying that money for Ring and other home security, those the internet, the $2,000 credit card payment.
Mm-hmm.
This is all for past.
Mm-hmm.
+1 on credit card.
Mm-hmm. Thoughts about future safety? Some of them were highlighted in the example.
Chat, some future could be housing security, childcare.
Mm-hmm. So in the housing context, she needs a place to live other than where she is right now, because she's concerned about her safety there. So being able to have the funds to move, to live in another space. Anyone else see anything in that scenario that is, really critically tied to her economic well-being in the future?
Mental health counseling. Other things that maybe needed to heal from the.
What about the employment authorization, right? In the scenario we mentions that she has expired employment authorization and that she's been relying on her partner to help with that. So that definitely is a piece that we'll want to think about in terms of how might the court be able to help so that she can get employment authorization, which of course, her ability to work is conditioned on that. So something to also think about creatively. Part of this process also is not just identifying the harms and the needs for the future, but also conceiving of remedies that are going to ensure both economic and physical safety, right? That delicate balance that we are often trying to help folks think through. So how would this request for money impact her own risk assessment? Is it going to create further physical risk or risk to immigration, as folks have talked about? How might we structure the provision to increase safety? Are there ways that mitigate some of that danger? Is it likely to be paid? Is it worth her spending her time and resources in pursuing this? How might we structure the timing, amount, method of payment to increase likelihood in the future? So here are some strategies that I offer to promote safety. One is about bifurcating a proceeding. So what I mean by that is there are two pieces to the economic determination, right? There's the piece of whether or not the harm has actually happened and whether there's going to be relief granted. And then the second piece, which is really more about how much. And oftentimes a court can decide to bifurcate the proceeding. In other words, yes, abuse has occurred. We're making a determination that a civil protection order is something that should be granted, but we're not going to address the cost of it at this stage. So that might be safety promoting. We can build in payment provisions that minimize contact, just as we do in the child custody context or the child support context more generally, so that we're not increasing contact between a survivor and their abusive partner. We can request smaller installments. Sometimes $1,000 payment is more off-putting to somebody and more risk elevating than smaller $100 payments over the course of time. Those are just some strategies. And then there are strategies to promote enforceability. So being specific, I think advocates often have to remind judges in civil protection order contexts, even though this is an expedited process, the rules of due process still apply, right? This is a court case. It's not just a conversation. And so what that requires of us supporting survivors then is that we are helping them to get the most effective orders possible that requires specificity about what the thing is that they're asking for, as well as the amount. We might want to set review hearing dates so that if something hasn't been paid 6 months from now, the respondent has to come back to court and speak to whether or not they're complying with the provision. And if not possible, having the respondent report to court in writing is another possibility for supporting enforcement. We can also bolster enforcement by requesting direct payment to the court. So oftentimes in child support cases, people are making payments through the court. And that way the court has a record of whether or not they've received the payment. And down the road, petitioners are able to use that documentation to enforce the order. Also informal non-legal advocacy, whether it's letter writing by advocates to remind respondents of the provisions of a protection order and the timing that's been ordered by the court and the implications for not complying with the order. And then keeping in mind the civil contempt process for later down the road. So those are some possibilities. Other strategies. So oftentimes I've talked a little bit about due process, right? When I say that, I'm really talking about the fact that a major tenet of civil cases generally is that people have an opportunity to be heard. And so making sure as advocates, we're supporting survivors in including requests for economic relief in the petition. And if we don't have a chance to do that, might mean that we are then filing a follow-up petition to modify the protection order or amend the petition. If there's an interview, somebody goes in for a temporary protection order, and then you meet them after they've received that, you might need to amend the petition to include other pieces of economic relief that were not part of the initial filing. So again, somebody talked about keeping up with all the paperwork. Yeah, there is a lot of paperwork because if judges are doing this right, there are processes that they need to adhere to, but that also means that then they have to be responsive to that process. So being able to step in and say, no, we filed this, it was served upon the respondent, they had notice of this piece of economic relief, then you're putting yourself in the context of being able to present that to the court without question. And then some folks talked about costs unknown. When people don't, if there's a cost that's unknown, right? In the example of Sally that we just read about, she knew that there were unknown costs, right? She had surgeries and also knew that there was going to be follow-up procedures. And so one strategy would be to request a continuance, in other words, delaying the case until there is documentation, the medical bill, or whatever the thing is that has yet to be determined. Another approach is to, again, bifurcate it. So you move forward with the original hearing and proceed on liability. In other words, this happened and the respondent needs to make payments to address that liability, but we don't know the amount of it. So later we're going to set a date to determine the amount once we have that documentation. If documentation is unavailable, You can also consider entering into a consent modified protection order with that amount. A court is going to need documentation of the specific amount. If you don't have that, there's always opportunities to negotiate with respondents about, we know that this bill is going to come due. We don't know the exact amount. And so we're willing to settle for a lesser amount and forego the court process in order to get that amount. So these are some of the strategies. And then that is all in the vein of preparation, right? Filing the petition, gathering, identifying what the economic harms are. And then we turn toward this piece of making the economic case. Again, critical to this part is demonstrating the nexus between physical safety and economic security. Being able to do that is going to come out in the process of proving it up. So we need evidence to prove that harm. Examples might be photos of injuries, destroyed garments or people's clothing, medical reports. All of these things are going to be necessary to prove the economic harm. That's the harm itself. But in addition to there being an economic harm, we'll also need to show the amount of that harm. We can't just say this cost $500. There needs to be proof of that. Receipts for property damage. In the case of debt, like we talked about before, that might mean credit card receipts or rental checks or letters from landlords demanding payment. And then we also can prove it up through survivor testimony. So illustrating the link, this critical link between the protection order's purpose, which is violence prevention, and the economic costs that we're asking for. So for example, a survivor might say, his attack caused me to incur $500 worth of medical treatment. Or a more indirect example might be, without replacement of my suit, I won't be able to go to a job interview, and I won't be able to have the funds to stay safe. Or future harms. The damage that he did to my front door leaves me open to future attacks by the respondent, and I therefore need the court to order that he pay for that damage so that I can remain safe. So really making sure that the storytelling that we do in the context of these protection order proceedings illustrates that link between her physical well-being and economic needs. Okay, so these are along the lines of arguments, and so I share these with you knowing full well that advocates most of the time are not making these arguments in court, but that advocates can share some of these with attorneys that they're partnering with or with pro se litigants, helping them to make these connection points. So really being able to illustrate how economics will impact this case in particular, and sharing some of the social science that exists, the studies that exist to help educate judges on the importance of economic security. Pointing out, right, we all talked about, how is this possible? My state has all of these economic provisions and this judge is apparently not awarding that. I think it behooves us as advocates to share with judges the Civil Protection Order statute, and in particular, those specific provisions that carve out economic relief so that judges have the tools to be able to do this work, as well as, like I said before, relying on catch-all provisions where creativity is needed to connect it back to that statutory intent of safety and future violence prevention. I'm not going to go through these. And then lastly, in this broader process, it's really about enforcement advocacy. So there are, going back to the Sally scenario, if you imagine that the court ordered that respondent pay $2,000 in credit card debt, over the course of the next 12 months, right? $100 per month. Payments to be made to the court on the first of each month, and then respondent fails to pay for the first 6 months. Okay, so let's imagine that's what sort of came out of that civil protection order context. The credit card debt was ordered, payment of credit card debt was ordered over the course of 12 months. Respondent fails to pay after 6 months. Do folks have any ideas about how you might be able to follow through on enforcing the protection order other than contempt hearings? Let's put that aside. Do you have any ideas? And when I say how, oh, okay, yeah. Some of this is, again, just want to be attentive to people's different roles and different contexts. Some people will never have an opportunity to say a word to the judge, but so when I ask these questions about enforcement, advocacy, I'm really talking about how, in that case, you're supporting the survivor in the advocacy process. Okay, so there are a wide variety, given that advocates do their work both in the courtroom and outside. Some of the enforcement work is done through third parties, right? So with lending institutions, for example, we talked about ordering that debt be repaid, or we've also talked about stay away provisions, and we've also talked about some of the housing related relief. So once somebody has a protection order that has determined that a respondent needs to either pay back debt or stay away from their place of employment or stay away from their housing place where they're living, advocates can help survivors in leveraging their protection orders with people occupying all of these positions, whether it's with a lending institution or with an employer or with a housing official who's demanding payment when we know that pursuant to the civil protection order, the respondent is obligated to make those payments. These are not guaranteed solutions, but rather different ways that civil protection orders, when they have economic relief, can be leveraged to support some of that non-legal advocacy. We can also go about enforcement advocacy directly. Advocates can by using and reminding abusive partners or harm doers of the protection order's existence itself and the terms of it. And I think I mentioned before, letter writing can often be an effective way of attaching a copy of the protection order with all of its provisions to try and support in that compliance or enforcement. And then lastly, through the courts. Do folks have any ideas of like how Sally might be able to make out a case for civil contempt, given some of the circumstances that I just shared with you about the credit card debt in particular? So civil protection orders can be enforced through civil contempt actions, which means that when the protection order has been violated, petitioners are able to file a motion for civil contempt that cites the terms of the protection order, including the economic terms, and respondent's failure to pay. That then creates an opportunity for the survivor petitioner to go back to the court, provide the documentation of that lack of compliance, and have the judge make a determination and order that respondent comply. Sometimes the justification that a respondent is going to raise under those circumstances can be like an inability to pay, but they have the burden of making out that case. And all the more reason why the specificity that we talked about before, like being really specific about types of payment and the timing of it, is critical, so that when you're in the place of moving for enforcement, you're able to clearly show what the terms were and supply evidence of non-compliance. And then I added here modification hearings, because sometimes there's not compliance, and the reality is that it's unlikely to happen even with a contempt proceeding. So people can apply, can petition to modify it in light of what is feasible, and that often involves taking a look at what the circumstances are and coming up with a modified order that is more likely to be something that will be enforced, or that the respondent will be able to comply with. So that's a lot of information, but hopefully gives you some juicy ideas about how you might use a tool that you're using today to expand the ways in which survivors are able to access safety through thinking expansively, coming up with really creative arguments, as well as all of the evidence and documentation to support it, and then passionate advocacy and helping survivors to tell their own stories that link the economic piece with their physical safety in ways that judges are really going to be able to understand it and see it through that in particular individual's lived experience. I will stop there and welcome questions. Also, I just want to say that there is a chapter in CSAJ's guidebook on consumer and economic civil legal advocacy that lays out a lot of what we talked about today and provides more resources and strategies for folks to support this type of advocacy. And we will share that link with you so that you have it as a resource.
There's a question and a comment I'll lift up and welcome while I do that. If others have any other questions, feel free to drop them in the chat now, and thoughts to what already is. Someone asked a really good question. I can't remember at what point it came up, Erica. You touched on it a little bit for those who can't speak during protection order hearings, but how else can you share this kind of information with a judge or with a court from social science research to some of the specific provisions and the examples that we've talked about? What are some ways that could happen?
Yeah, I appreciate that. In terms of the law itself, if you are working with a pro se litigant, so somebody who doesn't have an attorney, the burden is going to fall on them to lift up the law in that case. And that might mean them saying to the judge, citing that there is a particular provision in the statute. So if you're able to coach somebody about what that statutory provision is, that's helpful. Another way of doing this is in the petition drafting process. People can be really explicit in their petitions about when they ask for particular pieces of economic relief, also mentioning the statutory provision that's connected to, so that when a judge is reviewing a petition, they can clearly see that their statute supports what the petitioner is asking for. Sometimes people can also attach things to petitions, right? We attach evidence to petitions often. So being able to, evidence can be for that particular person. It can also be social science that's attached to it. And if you're working with an attorney, of course, that's expanded possibilities, because the attorney can make some of these arguments and cite to the provisions directly as well.
And what an example of perhaps like partnership or different kinds of systems advocacy. We've worked with some communities, for example, who have partnered with courts to do like studies to understand outcomes for survivors, and that can be a way to partner with and get in alignment with judges and court actors to understand what is coming in and out of courts, and can be a way of doing some of this advocacy outside of specific cases or doing cross training and that kind of stuff. And then someone made a comment that I think important, and the intersection of immigration has come up throughout, that when survivors whose immigration is dependent on the abuser, they're more at risk of taking the decision to file any legal remedy, because even if they get housing and other financial services from DIA, the organization, for example, they can't continue paying due to lack of status. And so just thinking about the complexities and perhaps some of the additional creativity or partnership that sounds like we could really tackle in a future learning exchange, or kind of think about.
Yeah. In this case, in the scenario that we talked about today, parts of this were from a client who I had worked with, and the employment authorization piece was something that she was struggling with because she was very eager to work but couldn't get a job without that expired, without her employment authorization renewed. In our protection order case, what we did was ask the court under the catch-all provision to order that the respondent do the work that was needed to get her employment authorization reauthorized. And that is what the court granted. So again, like thinking creatively about what the court can do. It may not be like providing funds, it may be things that the respondent needs to do in order to open up economic opportunities for her.
Great. And Kiro needed to hop off and so she let me know. I just dropped an evaluation link in the chat. Please let us know what's sticking with you, what else would be helpful. Give us feedback. It means a lot to us, and we use it in how we plan and design all of this going forward. So that, and it's also a place to ask other questions and to make sure that if we didn't address a question or a thought that you may have had, lift that up there. And we will be sharing the recording, PowerPoint, and other resources that Erica mentioned directly in email. And then we post all of this information on our website as well. But everyone here should get an email directly from us. Look forward to that. And let us stay in touch if you need individual support, organizational support. Our email address is right there. You're welcome to touch base with us at any time, and we can connect and have a chat.
Thanks, everybody.